Welcome to Accelerate, a DLA Piper hosted series focused on AI. During the series, we will help demystify the complexities of AI regulation, risk, and how to harness the opportunity that AI brings to businesses across the globe.
Hi, my name is Francesca Pole. I'm a data and AI lawyer based in our Amsterdam office, DLA Piper.
And I'm Claire O'Brien. I'm a technology lawyer based in our Dublin office. And today we're speaking about AI and risk assessments. So the EU AI Act does include certain legal obligations relating to risk assessments. If you're the developer of a high-risk AI system, you'll be required to have a risk management system in place to identify, analyse and mitigate risks. Also, if you're the user of certain types of high-risk AI, you'll need to carry out a fundamental rights impact assessment. Now, we speak about those specific types of risk assessment in a separate video. But even where it's not a strict legal requirement to do so, many of our clients are finding that it is good practice and common sense to carry one out to ensure the responsible deployment of AI.
So where do you start with AI risk assessments? Well, really at the initial stages, you're going to need to map your AI system, and you need to find out at the very earliest stage. So when you're procuring the AI system or developing that AI system. And essentially, you're going to need to establish two things. Firstly, what role the organization is playing, and secondly, what risk level is associated with the system. This can form part of an existing risk assessment process within your organization, or it may form the foundation for an AI governance initiative. It's also really important to know that within the European AI Act, the focus is really on health, safety, and fundamental rights. But you as an organization may decide that you want to extend that risk assessment process to include other risks, such as environmental risks or the impact on business confidential information.
So what should it include? Most risk assessment processes will involve the following 5 steps: identifying actual and foreseeable risk, analysing the risk, often based on a severity, likelihood of harm matrix, ranking the risks, treating, which means mitigating or eliminating the risks, and then ongoing monitoring. So while a lot of work will go into steps 1 to 4, it's really important not to overlook step 5, the ongoing monitoring piece, because risk assessment isn't a static document or process. It obviously involves ongoing monitoring, and assessments should be revisited, especially when an AI system is updated.
And of course, it's also important to remember that within the European AI Act, if your system falls under that, you're likely to have support. So if it's a high-risk system and you're a deployer, the provider needs to provide you with instructions for use. And this document is going to include an assessment of existing and foreseeable risks and the circumstances where those arise. Also, in relation to fundamental rights impact assessments, we're expecting a template from the European AI Office to assist with the drafting of those assessments.
So risk assessments are a really useful tool for organisations who are looking to deploy AI responsibly and ethically. And they're also very helpful to identify the right resources to devote to developing technical and organisational measures to mitigate risk. Thank you for listening.
Thank you for listening to this episode of Accelerate by DLA Piper. For more on AI, check out our YouTube channel for more videos like this, and click subscribe to stay informed. You can also take a look at our AI focus page, dlapiper.com, for further insight and thought leadership, and get in touch direct to discuss how we can support you in navigating the complexities of AI.